Randy Miley is here with the plaintiff defendant present pro per. Mr. Miley, did you have any discussions with defendant?
I did, Your Honor. We weren't able to resolve anything. I would just point out that we have discovery that's been deemed admitted. We have adverse presumptions. The issues are custody, alimony, child support. Mom did an FDF apparently prior to the last hearing. You ordered her to do another one. She hasn't done that. Your order says that you can't address child support, alimony, or I forget what other one was that. That's in the order, unless she does one. So our position at this point is that Dad's seeking primary custody or potentially even sole, and most of the financial issues are either going to inure to Dad's benefit or can't be addressed at all.
And they're sharing custody at this point?
They have, I think it's teenager preference, 7 o'clock on Fridays, I believe, is the current order.
Okay.
Dad is an offer of proof. Dad is willing. Dad would like primary or sole. Dad's willing to move over into the area so the child doesn't have to change schools. And then when Dad believes Mom has a couple issues with medication or whatever it is, Dad's position is that once Mom can kind of get her issues with medication and she gets her life back, she's working and stuff, Dad will, as long as she's doing well, Dad will give her joint custody again. He's not trying to steal custody. Dad just is concerned based upon what's going on now.
What are the main issues of concern beyond the ones that were briefed or discussed as to?
His grades aren't the best. Mom essentially doesn't oversee him and things like that. Although there's no doubt that the boys love their mother and stuff like that. There's one child now, the 18-year-old has emancipated. The one child is 15. Grades aren't good. Mom apparently, according to Dad, is Mom kind of Disneyland Mom. Mom is on heavy-duty medication and has been for several years. He recently found out that she's upped her medication again. So Dad's concerned about that. Mom hasn't worked in over 3 years, isn't disabled, but basically refuses to work as Dad's position. And, you know, Dad, at this point, Dad's got a medical condition. He can't work the overtime anymore, and he just can't afford to have two households where Mom lives separate. So Dad's basically asking at this point to end everything, to get primary custody and have Mom evaluated and dealt with whatever issue she has.
Okay, what would you like to tell us?
I'm not Disneyland Mom. My son, his grades do go up and down because my son has special needs. He has a disability, so he has an IEP in place. And he has problems reading and writing, so that's why his grades go up and down. My attorney withdrew. I was injured at work, and I had all the documentation, but my attorney did not file anything.
Then he shouldn't have been allowed to withdraw until he submitted all the...
And we would point out that apparently was in April or May. I mean, Mr. Mann's been out.
He didn't withdraw until
months.
June 5th.
And that may be, but he withdrew prior to the motion to compel.
All right. What else would you like to tell us?
The motion to compel, I turned in the paperwork on May 6th with his paralegal, and it was supposed to be turned in, and it was never turned in. And then there was a motion to compel for discovery, and the date was set for my son's graduation.
Okay. They said in their brief that you have a serious physical reliance on narcotics, Oxycontin in particular, and that you're not able to return to, the main reason you can't return to work is because of your disability caused by too much pain medication and other matters.
I know I hurt my back at work. I applied for Social Security disability, and I was denied it based on my husband's income. And I was working at TSA, injured my back, and was...
I don't think they can deny it based on the... I think that they could perhaps adjust the amount based on your husband's income, but you're either... If you're going to be certified as disabled and it's justified, they'll certify you as partial or permanently disabled. I think his income could have an effect on the amount of the grant or payment. I don't think it's relevant to actually whether you're medically certified or not. Mr. Miley, are you aware of that situation?
My understanding is that they're independent and that they wouldn't look at husband's income. We would point out, she was ordered by stipulation to provide a HIPAA release on March 5th. She never did. We did discovery asking for a HIPAA release again. She never did. We asked for medical records so we could establish whether Mom does have an issue or not. She never did. Dad knows that she was denied disability and she hasn't worked. And apparently, it's our understanding, I think it's stated in the brief, Mom doesn't seek physical therapy, doesn't do pain management, doesn't essentially do anything else except once a month she goes in and presents for narcotics. And then Dad just found a receipt or a letter or an email, whatever it is, that came to both of them, stating that even though her insurance doesn't recommend it, the doctor has approved her for more medication, and so she's going to wind up getting even more medication. Dad already thought she was on too much, but obviously if she hasn't supported herself in 3 years, they've been separated for 3 years. At this point, Dad's saying Mom needs to get a job. We asked for a job search at the last hearing in March. That was not the order, but Mom has no verifiable injury, hasn't had for several years. We're asking for Mom to get a job, basically be a productive member of society again.
They've been separated 3 years?
3 years. Almost four, apparently.
How about the remainder of this property, like cars and...
Our decree talks about disposing of it. There's not much. I think there's 3 or 4 cars. 2 cars are going to go to the kids. The kids are actually making the payments. I think one of them is, let me find it real quick.
Well, the oldest is making the payment on
Cody. Real estate, there are no real estate. Tim is to receive the 06 Toyota Tundra, which I think is in possession. I don't know what the value is. Vicky's received the 97 Caravan. What Dad's proposing is there's a 2007 Nissan Altima that's in Dad's name, and he's responsible for it. But Cody, the minor child, or the child is now 18, is paying $172.50 a month. So the child's paying for it. What Dad's saying is that it's really the child's car. The child continues to pay for it. It's the kid's car once he pays it off. If the kid doesn't pay it off, Dad will pay, but it's Dad's car. There's a 94 Toyota pickup truck that's supposed to go to Tim, which is a 15-year-old. He's asking for the same thing. It's registered in his. That one may actually be paid for.
Evan. It's supposed to go to Evan.
Okay.
Yeah.
But he asked that when the child turns 16, it goes to Evan. Same thing. I think Evan, is it paid for already, the Toyota?
Yes.
Okay, the Toyota they have to worry about then. But those are the 2 cars that are reserved for the kids. There's a
Evan's
pension.
born 1999, he's 15.
Correct.
How old is Cody?
He's emancipated.
Is 18.
He's born 1995?
Correct.
Okay.
And then there's a retirement account they need to do a quadro on, but that's
Is anyone interested in any testimony from somebody?
on the quadro or on the cars or anything.
Any of it, the trustee, any of it, are you...
I mean, we'll submit, Your Honor, if you'd like.
Do you have any questions for her, or...
I mean, if I have, I mean, I can ask questions. Our position is that we have an adverse presumption on everything. We have a request for admissions admitting she, because they're deemed admitted, admits that she has a substance abuse problem.
Well, that's why I need you to develop that for the record.
And I mean, I can present the motion, I can present her.
We don't have to get into a lot of detail on it, but at least on those issues, some exploration, either through what's occurring in reality, plus it being foreclosed by the discovery issues as to the stability or chemical dependency issues that are being referenced.
Well, here are the questions, Your Honor. You can tell me. You're talking about her job and her
Go
work.
ahead and you can pose some questions to her, and then represent to the court that they were already deemed admitted by not being responded to. But then also, maybe she should be asked a few questions as to those issues, the stability and chemical dependency. I don't know the extent of what she's using or not using. So maybe some guidance on that might help. Well, let's start with that. What's the level of your prescriptions at this point? What are you prescribed for?
I'm sorry?
What medications are you prescribed for?
I'm prescribed oxycodone.
Anything else?
Yeah, metoprolol for my heart. Valium for anxiety.
How many Valiums do you take a day?
Half. One at night.
Half a bar, so a gram.
Okay. And how about the oxycodone? What's the strength of each tablet, and how many?
It's
You take
10
it in what
milligrams, and it's between 4 to 5. And that's been
Hours?
I'm sorry?
Pills per day or hours?
4 to 5 per day, I'm sorry.
How many hours between it?
4.
You take one at a time or two, or?
1.
All right.
And that's been the same prescription since I've been injured.
Okay. Do you have any knowledge of Evan, whether he has a preference of where he'd primarily like to live, or you don't know?
Yes, he said he would primarily like to live with me, and he said that he would, before any decision is rendered, he would like to be talked to about
And
it.
you said you have a disability that precludes you from working?
I can't stand for very long or sit for very long. And that's why I had asked for a continuance so that I could have
Is
somebody.
your driver's license valid
Yes, it is.
and the insurance?
Yes.
Okay, Mr. Miley, did you have some questions?
Well, I'm looking for the exhibits, but your position is that your medication hasn't changed?
No, it hasn't. The letter he's referring to was mail that was sent to his address with my name on it.
But do you know why it talks about you've been approved and you're going to get more medication?
Because it has to be a prior authorization every 6 months, so they send the same letter every 6 months saying that it's been prior authorized.
I'll have to look for it in a second. But for the request for the facts that are deemed admitted, Your Honor, and I can show you a copy, I can publish a copy, but admit that you've been deployed at the Federal Transportation Safety Administration, or TSA. These are all deemed admitted. Admit that you were terminated from your job at TSA after refusing to return to work, but nonetheless being deemed fit to work. Admit that you made efforts to obtain disability insurance and were denied such benefits. Admit that you have the ability in functioning in a normal day-to-day activities, including but not limited to hobbies such as hiking and biking outdoors. Admit that physicians have prescribed to you with medication including oxycodone, Percocet, which you have taken over 10 years. Admit that during the course of your marriage, plaintiff has not been involved in any acts of domestic violence. Admit that you would refuse to undergo treatments such as surgeries and physical therapies which have been recommended to you by your physicians for your pain. Admit that you have been denied disability insurance. You refuse to obtain meaningful employment. Admit that after being fired from your position at TSA, you made no efforts in searching for employment. Admit that you and plaintiff had separated from one another in 2010. Admit that you are willfully underemployed. Admit that due to your refusal to obtain employment, the financial responsibilities fell solely on the plaintiff. Admit that you refused to provide your financial information to this court. Admit that there is no sound cause which would preclude you and the plaintiff from exercising legal custody. Admit that you have admitted to plaintiff of giving away prescription medication to friends, including Deb, Gatley, and Nan Rosales. Admit that you did not appeal TSA's decision.
About that last issue, I understand the concept that the commissioner apparently on June 14th said everything would be deemed admitted if not responded to by the 16th, I guess 2 days from then. So I assume she didn't. But I'm also concerned whether there's, and we might establish it through him, is there a legitimate factual basis for it? I understand, but I understand matters are deemed admitted, but if we sent a question to someone, admit you're a giraffe, and they didn't respond, it doesn't make them a giraffe. It just means for the purposes of the hearing I can make that finding. So does he have a basis to believe under oath that she supplied to these friends?
You wanna swear him in?
Which would be highly irresponsible
Do you want to
and
swear him in?
illegal.
The parties in before you
Let's have
testify?
both parties sworn in.
Please stand, raise your right hand.
Oh, I'm sorry.
You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, now before he, have a seat, everyone have a seat, please. Before he's asked about that, pose that question to her as to those individuals, and she'll tell, and the question means not just did this happen as a matter of course, but even were there any isolated examples, and if there were, tell us when it was and what happened and all that. So go ahead and ask that.
To clarify, are you talking about just giving the medication to these two people, or are you talking about her
That
not being able
basically,
to?
because that's a crime, so I think still, so.
You're saying not ask her that question?
I'll ask her.
Okay. Did you ever give prescription medication away to anybody?
No.
Did you ever give prescription medication away to a Deb Gatley?
No.
Did you ever give prescription medication to a Nan Rosales?
No.
Did you ever sell a medication?
No.
Okay, I guess pose it to him because I imagine this material came from him, so go ahead and find.
And I didn't know if you want me to talk about something else. Are you aware of Mom admitting to you of giving away prescription medication to friends?
Yes.
Are you aware of Mom telling you that she gave prescription medication to a Deb Gatley or a Nan Rosales?
Yes.
Tell us everything
How?
about it.
She said that
When? Tell us when, where, all that kind of stuff.
when it was probably, she's had these medications for well over 10 years. And I know that she told me that because she wouldn't give Deb Gatley.
When did she tell you this?
I would say 8 years ago, 7 years ago.
What'd she say?
She said that their relationship was strained because she wouldn't give her any more medication.
And this is regarding Deb, you said, right?
Right.
How about Nan Rosales?
And Nan, they both were getting, I don't know what she had, but they were both exchanging medication.
Now, when you say they, you mean Nan and...
And Vicky.
Okay. And make sure
How
you're
long
talking
ago?
Deb.
See, they've been separated now 3 years, so it was towards the end of the marriage that Juan and Nan, so it would have been probably 6, 7 years ago.
Do you know if she's still doing it or not? Or the last time you guys were living together?
If it's that remote, it might not necessarily impact custody unless you're going to be dishonest about it.
I think what
I
he's...
mean, if you had shared medication with someone in the last year or two, or were currently doing it, would be much more of a concern than did you tell someone 7 or 8 years ago you can't help them anymore, because a lot of water's been under the bridge since then, and if it's not a current problem. But if I tend to believe him that something may have happened that long ago, and you choose to deny it, then I can enter an inference that all your testimony is false, because it tends to have the ring of truth to it, in part because, well, candidly, I believe him, because if he was going to lie, he would have made it much more current, and he wouldn't have given you credit for saying you're going to cut them off. But because he says it was 7 or 8 years ago, and because he said you made the commitment to cut them off because you apparently thought it was wrong to be supplying them, it tends to lend credence to what he's saying. So you want to rethink your response?
Now,
on that?
Juan Rosales is the person that he is renting from.
I didn't ask you who
And-
he's renting from. I told you that you can tell us that after. I asked you if you want to rethink your response, because in fairness, I told you, Mr. Miley, please. I told you that,
No, I'm sorry, I'm talking about
I know, to my mind, if he was going to fabricate, he would have made it sound a lot worse. He would have made it sound current, and he wouldn't have given you the credit. He wouldn't have conceded that you cut these people off. So when he says it's 7 or 8 years ago, and he knows that's remote, and he did say that you don't think it's right to supply these people, and that you cut them off, that sounds like he's telling the truth. So I didn't ask you who he's renting from. I asked you if you want to reconsider your answer. Then after you answer my question, you can tell me if you think he's lying and why. So go ahead.
No, I stand by my original.
That you never did?
No.
Okay.
I think Dad's concern is that she may be doing it now or to sell, to supplement her income. He doesn't have any information about it. We've done discovery, but if you want to get back to the letter, my client found the exhibit.
What did he find?
It's plaintiff's proposed exhibit, but it's a letter. She's got a copy of it. It's a letter dated May 6th. Well, the date of request was dated May 6th. The date the Express Scripts decided was May 6th. It says, we reviewed and approved your request to obtain oxycodone HCl acetamine tablet for an additional quantity above the limit allowed by your plan. This approval is effective for April 6, 2014 to July 5, 2014. And then it talks about how she can go get the medication. So Dad's concern is, again, she's been allegedly disabled for 3 years, but she's been taking these pills for 10. We know she hasn't worked for several years, for 3 years. She's apparently at least going above what her plan authorized.
What was the injury?
10 years ago or 3 years ago?
Well, yeah, 3 years
It's the
ago.
same
3 years ago is the back. I don't know about the 10 years ago.
No,
But we asked for I would like to tell you more. We asked for her medical. She never provided him with a HIPAA, so I can't tell you.
What's the purpose of this letter seeking further medication beyond what your plan authorized?
Are you asking me?
Yeah, well, I'm not going to
It's,
ask him. He's
I'm
not
sorry,
seeking the medicine.
it's a prior authorization that they have to the doctor's office has to call into the insurance company and get a prior authorization every 6 months. They've been doing
I'm
that.
trying to ask direct questions, and as I said, I want direct answers, and then you can give me the other detail. Were you trying to seek authorization for medication beyond the prescription level that your physicians had authorized?
No.
The letter tends to indicate otherwise. Would you read it again, please?
Medication coverage review decision approved. Dear Vicky Smith Bell, this is a letter from Express Scripts.
Did they approve it then?
Yeah, they approved it.
So they're giving her additional. They're authorizing it.
Your coverage has been approved. We've reviewed and approved your request to obtain oxycodone HCl administering tablets for an additional quantity above the limit allowed by your plan. This approval is effective April 6, 2014 through July 5, 2014. So her plan only covers so much. The doctor is asking for more. I don't know how she's paying for it, but from this letter, she's getting more than what her insurance company says she needs. This Express Scripts spoke to somebody on May 6th, and they've provided her, it doesn't say how much, but it says they're giving her more than what her insurance coverage is. I don't know how it was paid. I'm assuming she'd have to cash pay or pay the excess, but without any discovery, I can't tell you much more.
Was Mr. Mann at that hearing with the commissioner? I think he was.
No, he was at the first hearing. He wasn't the second hearing. I was actually in the hospital, so I had to have Eric Roy's office covered for me.
Okay.
You okay?
I mean, I'm just giving you a chance to respond to some of this, because the fact is that the commissioner had already ruled you're prevented from disputing some of these issues because you repeatedly refused to respond. Some of it may have been primarily the responsibility of an attorney you had earlier in the case, but you're responsible for, if your attorney dropped the ball, that responsibility doesn't pass to them. So
Can I answer that?
say whatever you want. What do you want to tell me?
I have.
Testimony is still that he invented out of whole cloth that you ever told him that you were not going to give pills to these girlfriends anymore?
I'm sorry.
Never mind.
I'm.
Because I told you, it sounds like you, again, helped your friends out for whatever reason 7 or 8 years ago, cut them off. And since if there would be an admission on it, that it might not really impact the case much because it's so remote in time and there's no evidence you're doing it now, but that if I believe it occurred and you choose to deny it, even though admitting it wouldn't have an adverse negative impact on your case, I'd have to enter a finding that despite all these warnings that you decided to be dishonest and foolish on an issue where if you had been truthful it might have not had much impact. And if you're going to be dishonest and foolish, when I tell you nothing's at stake if you tell the truth, then when something is at stake, if you're going to be dishonest when there's nothing at stake where the truth isn't going to expose you any repercussions, but you choose to be dishonest, then when something is at stake, you'll have 10,000 times more motivation to not be honest. So you're putting me in the position where I'm going to have to make a finding that he's telling the truth on that issue. Again, if he was going to lie, he would have said, she's dealing now, she gives it to her friend, she's doing this. He wouldn't have said it 7 or 8 years ago and that you eventually did the right thing and told these friends you couldn't give it to them anymore. That doesn't make sense. It's remote in time, and he's essentially giving you credit for ultimately cutting them off for making the right decisions. It almost borders on the nonsensical that he would have made that up. If he would have made it up, it would have been much more current and would have put you in a much worse light, and it wouldn't have given you credit for ultimately not sharing any pills with your friends. So, but if you're still insisting that you never did it, I'll just have to decide on the credibility of the testimony. So that, and apparently you want to maintain your testimony. That said, what else do you want to tell me?
Why else are you
Either
concerned?
side. What else do you want me to know?
Why?
My main concern,
You want us to stand or can we remain seated?
He can remain
Okay.
seated.
is that the amount of time that she's been taking these pills and trying to deal with her, she's not the same person anymore. I can't deal with her at a rational and what's best for anything. My main concern is for her to get help and get off these drugs. That's my main.
You're not trying to take primary permanently. You just want to make sure she gets whatever issues.
I just want her to get help. You know, either go through with something else. I mean, to me, she's been going to this. She's been getting these pills for 13 years. She goes to the doctor once a month because it's a narcotic that she has to go there, and he continues to prescribe them to her without any other further.
Well, do you believe there is pain associated with the injury?
No, she can hike.
What's the nature of the injury to you? What's your belief and knowledge of the nature of the injury? When did it occur? What was it?
It occurred well over 11, 12 years ago at TSA, she claimed. She claimed it to be a workman's comp thing. They said it was a lumbar. They said it was a lumbar.
What's your understanding of what happened?
What caused the injury, you mean?
Yeah,
Okay.
she's at work and what happened?
She would picked up a fan, I guess, a drying fan, evidently, and it twisted her around. And she went to a doctor, and they said that she had, I think they called it a lumbar sprain. And then the Department of Labor said, that's fine, you need to go to our doctors. So the Department of Labor doctors evaluated her and said, you're fine. And here's your return to work date. And she never returned to work, so she was terminated.
And that was
And
10
she's
years
been,
ago or 10
no,
years ago?
this is over 10 years ago.
Well,
She's been on these.
Why didn't they? If you had the serious injury, why didn't they certify that, or at least provide a temporary work release till they got to the bottom of it all?
I was fighting Department of Labor on, and I have doctor's notes that I've had discograms proving my injury, and I had to go to an independent medical examiner of theirs who said that there was nothing wrong with me, but I have other doctors' documentation showing my injury. And the latest one was, it was in appeal in Washington. I had a workman's comp attorney helping me fight Department of Labor. And it was in Washington for an appeal, and then come to find out the attorney wasn't an attorney and didn't follow through on his paperwork.
Do you have any other questions or how is the property all to be resolved?
Are you okay with our proposal for the cars? And there's a thing called a time rule for retirement that says that they calculate the day you guys are married, the day you guys are divorced, and you get half of that period. And that's pretty much the standard law. So you're going to get half of his retirement for the time you were married. And that, if you judge, and the judge can probably say that's pretty much the standard.
Have they agreed as to who keeps what cars, and are they?
I was asking about that.
They've been separated long enough. Do I assume they each keep their own property and debts, or that
They don't have a house. Yeah, they don't have a whole lot of
I don't
assets
have
and
any
debts.
property. He left me with a car that is breaking down every time I turn around and has no.
Anyone have any questions? Do you have any more questions for her? Do you have any questions for him? And if not, if no one has any questions or any other witnesses, then the parties can make statements, I guess, closing statements until.
Have you tried to find a job in the last 10 years? When was the last time you worked?
TSA.
Okay, how long ago was that?
It's been about.
Just roughly, is it 3 years, 10 years?
13.
13 years?
10 years.
Okay. So you haven't worked in 10 years, is that correct?
Because I can't sit for very long or stand for very long.
Have you gone to see a vocational rehab specialist about other jobs you could do?
No.
Can you be a babysitter? In fact, we have questions about that, don't we?
Yes.
If you want to get into the other interrogatories, we say, what attempts have you had to get a job? Have you gone in for vocational rehabilitation training? I mean, these are all interrogatories, not admissions. These are all deemed against her. But that's why I was going to publish these to you, Your Honor, because they go in, I mean, I can read them into the record, but they go into great detail. Asked her at one point about medical prescription, specified going into detail about your Social Security disability, when you were diagnosed, medications, limitations, nothing. Describe in the last 10 years which you have been out of work. Please detail your unemployment, the reason for such unemployment, nothing. Please state your living arrangements, nothing. Please detail, from 2005 to the present, detail any and all medical providers you sought medical assistance, et cetera, et cetera. There's the HIPAA release. Provide all details relating to instances in which you've obtained state welfare. Describe in detail what you've done to ensure regular contacts between the parties. you know, what jobs have you attempted or tried to do since the separation? Please provide a statement of what you believe to be an appropriate custodial arrangement. What would preclude the plaintiff from being afforded joint custody? Please provide a summary of your normal daily routine, both weekdays and weekends. You know, list all property of the 5,000. I mean, it goes into detail. I can go into more. There's, what are you going to have a trial? You know, have you describe in detail any and all instances where you had willfully left, refused to work, or experienced periods of unemployment. Exact dates, why you left, why you refused to work, what you've attempted to do to find a job or to modify your skill level. I mean, there's
Your Honor,
they're all over. But
Your Honor, can I respond
Yes.
to that? On the 2nd of June, Tim came to my house to give me, because he brings me money once a week for food, maybe. And that was when, and he told me I had some papers that I needed to sign first. And that was when I found out, and he was serving me with papers for the Discovery Commission meeting on the 13th, which was my son's graduation. That was my first, and he...
Why didn't you make arrangements to either contact Mr. Mann, or if you no longer had him, contact the judicial department and say, it's my son's graduation, can I have a continuance, or contact Mr. Miley or plaintiff? Did you make any efforts? Did you send,
Yes, I did.
Did you send anyone an email that you can show me saying, it's my son's graduation, I don't want to attend that day, can I have it continued? Did you send that to anyone?
Yes, I did. I came down here and submitted the information.
Did you ask him? Did you ask his attorney? Did you ask your attorney?
My attorney had withdrawn.
Because I can't entertain those requests unless you put it in formal motion, and first you have to ask the other side. Did you receive a request to continue it or something?
we received an opposition.
They would have continued it if your son's graduation was occurring.
I think what she did is she did it too late, Your Honor, at that point. And at the time, we had trial scheduled for short. We waited as long as we could to do the motion to compel. We had trial shortly scheduled prior to, and then that's when I was in the hospital.
Bound by the commissioner's order, no one objected to it. It became an order. So unless someone files a motion to eliminate or change it in the future, I'm bound by it.
We asked her, Your Honor, for things like, please provide a list of all pain management therapies you've sought over the past 10 years, list of all pharmacists and pharmacies you've received prescribed drugs from for the last 10 years so we can see if she's over prescribing. Please provide copies of your personal bank statements for the last 5 years, cancel checks for the last 36 months. You know, we asked for documentation that either supports her case, none, supports his case, none. You know, I mean, and we've asked again, provide a HIPAA release in this request for production. So we tried to get the information to either prove or disprove my client's allegations. Mom flatly refused. And again, she and her attorney both agreed to give a HIPAA release at the initial hearing in February.
Do either side have anything further?
I'd asked for a continuance. I had
We're
called.
already here. I can't continue it now. We're
I
already
am,
here.
okay. I don't.
Done in advance. Does anyone have anything else?
I guess not.
Anything further from either side?
Anything else you want to add to that?
Anything further?
Just that Dad also believes that she should. I mean, Dad would like primary custody subject to, and he's, like I said, he doesn't have to do this, but he's still willing if Mom can. If she gets a note from a doctor saying she doesn't have an issue, that may be enough right there.
Okay.
But he's asking for primary. He's willing to move into the district. At this point, he's saying Mom needs to get a job. At this point, we don't really believe that the court can adjudicate alimony, so we're asking at this point for zero alimony. Dad is willing to waive, I think, child support for Mom so she can try and get her issues in order. And we're asking for the property to be disposed of, what we said, which is, I think, the 4 vehicles.
Okay.
And
The court's going to grant the parties an absolute decree of divorce and award joint legal custody. The primary physical custody will be awarded to the father. If the mother repetitions the court within 6 months of entry of the decree and indicates that she's in rehab or otherwise gets a letter from a physician indicating that she doesn't have any issue with medication, etc., then we can revisit it. If she lets 6 months pass and she doesn't challenge the ruling, then it'll become a permanent or ongoing custody order, because the court does note that these issues have been removed from evidence adverse to defendant by her not responding to the discovery commissioner's orders, and she still didn't respond to the discovery, so it's all deemed admitted. And based on that, the court does find that the medical situation and/or the chemical dependency issue does preclude the mother from having the primary custody at this time, but again, she would have 6 months to repetition after entry of the order to either show she's in rehab or that she has a doctor's clearance. Now, if the doctor indicates she has a viable injury and she's not over-medicated for it, that might be fine. If it indicates she's not injured, then it raises the question, then why is she being administered pain medicine at all? So, but
Your Honor, he hasn't even
that's fine.
seen
You're
the
not going to
kids.
probably produce anything, 'cause you haven't produced anything yet. And if you don't respond and produce evidence or testimony or documents in support of your position, I have to handle it the same way the Discovery Commissioner did and indicate that those issues are resolved adverse to you. You're disputing all this, but you think that you have the right to just verbally deny something in court
Your Honor,
if it's
I came
legitimate
down
issue.
here to discuss.
You have to follow the rules. If someone puts an issue in place as to your medication, your supposed injuries, anything else, you have to provide the requested documents or releases if you wish to take dispute with what they're saying. Just like if you had requested information, if he had a medical issue and you requested information, he would be required to respond. So at this point, the court is awarding the parties joint legal custody, and again, is awarding the father primary physical custody. Number one, because the key issues concerning defendant's stability and use of narcotics has been resolved adverse to her by the Discovery Commissioner's orders. Plus, this court does independently believe that based on what it's heard, regardless of the discovery request, that the mother does have some medical and/or chemical dependency issue, which does preclude exercise in primary custody at this time. And the court also finds that the testimony of plaintiff was believable as to her sharing medication with some friends. It may be remote in time, but she chose to deny it, which means that it also, as I indicated, that causes the court to maybe disbelieve or not accept a lot of her other testimony because she didn't come clean on the issue. So the divorce is granted, joint legal custody is ordered, primary physical custody to the father. If after 6 months of entry of the decree, the mother does not repetition the court successfully, then it'll be an ongoing primary custody order to the father. And for this to be effective, he must move into the district. And some level of teen discretion is imposed, and the father will have 4.5 days a week, and the mother will have 2.5 days a week, but some level of teen discretion is imposed. The mother will not be required to pay child support based on extreme financial hardship. There's no alimony ordered, but she has, again, just like on the custody issue, she has 6 months from the time to reopen, of entry of the decree to reopen this issue, so the court will reserve jurisdiction. But I can't order alimony because, again, the Discovery Commissioner resolved all of these financial issues as well as the custody issues, resolved all the financial issues adverse to you. You've signed no releases, not just for medical information, you've signed no releases for financial information. You've provided none of the financial documents sought in discovery, banking records, otherwise. No work search list, nothing, no financial statements. So the court is deprived of the ability or jurisdiction to order you any alimony based on that total non-rule compliance. And, you know, I'm not sure if most of these problems were occasioned by you not the period you didn't have a lawyer, or if during the earlier period you did have a lawyer, whether or not there was the same level of total neglect of the rules and total non-compliance. But
Your Honor,
you've kind of boxed the court into a corner there, and I do recommend that if it's ascertained there's a problem, that you do enter rehab, and that should be a basis for for revisiting this matter. The property and debt division, as placed on the record, will occur. Each party is awarded the marital share of any accrued employment benefits or investments that
Split the quadro.
that have accrued to date. If there's a quadro necessary, the parties will split the costs of any qualified domestic relations order. So if there's any accrued work-related benefits or anything of that sort, they'll be divided according to the marital share each party will receive. The parties have been separated for several years, and I haven't heard, I asked about contested property issues. I haven't heard anything really. So aside from the issue about the quadro, if there's any work-related benefits to divide, each party will be awarded the property in their title, possession, and control, since they've been separated so long, and each party will be awarded any debts in their own name. If it turns out there are some joint debts that weren't discussed or disclosed until the court will reserve jurisdiction, but until such time, if any, the court deals with that issue, those will be considered joint debts. So, again,
Your Honor?
the issue of alimony, jurisdiction's open for 6 months, and the issue of custody, the jurisdiction's open for 6 months after entering. That's about all I think we can really do.
Two issues I just want to clarify was, one, Your Honor, is he's willing to do the timeshare. What I was going to say is Dad's responsible. I was going to recommend that the parties stipulate to Marv Schneider, or order to Marv Schneider, unless they agree to somebody otherwise. That way, by default, Dad will contact Mr. Schneider to at least get the paperwork going,
Okay,
or whatever
so,
it is. Mom.
If they want to choose someone else, they can, but if they can't or don't have the knowledge of who to
Right.
use or who to retain, then that'll be the fallback position. So ordered.
The other issue we're asking, Your Honor, is that if Mom does come in the next 6 months with this letter, whatever it is, we're asking as part of the order that prior to her either filing or the hearing being heard, that she respond to the discovery we sent out, because it goes into a lot of the money. And if we come in, I don't want to be sandbagged with it. We need to see your prior medical and stuff to see if it's a real doctor or it's a...
Well, it is true that that's so ordered and will be in the decree, because it is true that even if you come back and you get good clearance through your physician, you still have all these issues which technically were resolved adverse to you. So you would also have to first unwind that and bring the appropriate motion, which would require an attorney, quite candidly, to have those admissions set aside, shall we say.
I wasn't saying that, but the doctor may...
However it's to be phrased. You know.
What I was going to say was the doctor may think that she's okay, but she may be going to 5, and I don't know if it's true or not, she may have 5 pharmacies she's going to, so she's getting 5 times the meds, but the doctor doesn't know it. Doctor says, oh, you're fine, and we see this all the time. We get the DEA records in there, and that's why I'm asking for
Well,
discovery.
obviously, if a letter from a physician might be sufficient to get her foot in the door. It doesn't preclude plaintiff from defending his case and indicating that there's doctor shopping, or that the doctor, or to augment her medication, that she's shopping different doctors, or even if that isn't proven, you still have the right to challenge the underlying medical conclusions of the physician, which get back to the point where if they want to challenge it,
We need the
then you
record.
better be signing the HIPAA release.
Well,
So I can't
and the discovery.
I can't change custody to you or grant a joint physical arrangement if you're going to continue to stonewall and block their access to your medical records. You're saying this is the situation, that you're legitimately injured and the medication is legitimately to address that issue, and that you don't over-medicate, but that it's an injury which does not preclude you from exercising custody, but that it does preclude you from gainful employment. All that may or may not be true, but before I arrive at those conclusions in your favor, you have to have them have free access to your such records. You can't say you expect those conclusions to be accepted, but that you block the Mr. Miley.
Yes, sir.
I can't rule that. I can't create a climate where I accept those conclusions without them being able to
Right, I
to
understand.
challenge it. If you're going to say I'm fine for custody purposes, but I can't work, and that the injury is legitimate, and that I'm not over-medicated, and that I don't shop for additional medication or doctor shop, if you're making all those representations and he's putting some of those in dispute, before I accept everything you're saying and change custody to you or split the custody half and half based on what you're representing, they have a right to challenge those allegations. And you should be very open about letting them have access to the records if the records are going to support what you're saying. And if you're saying the records are going to support all this, everything we just discussed, then why aren't you allowing access?
I thought my attorney
With or
had
without an
submitted
attorney,
it.
how long does it take to sign your name on a medical release? 5.5 seconds? If they have one now, you could sign it. If not, you can go to his office and sign it. Or he can mail it to you if you don't.
At this point, I think we'll
I
wait to see
came
what
down here and
happens.
tried to answer the questions for discovery.
Don't answer him. He's saying if you didn't have time to answer him and you didn't have the assistance of an attorney, sign authorizations, let them get the medical and banking and financial records, let it be their headache. They may have obtained all that and been satisfied with it and come in and offered split custody down the middle, but you can't stonewall and obstruct access. If all these records are going to support what you're saying, that you're disabled, but to the point where you can't work, but you're not disabled to the point where it prevents you from exercising custody, and if you're saying that you're not over-medicated and that you do have a legitimate injury that requires this level of prescription, then why would you want to block the
I
records
wasn't
that
trying
would
to stonewall,
establish
Your
that?
Honor.
Why
I was
would you
trying to
wanna-
get legal aid so that
Why
I
would
would
you want
have
to block?
representation.
Why would you want to block the access to the information that's going to back up what you're saying?
I wasn't trying to block it.
Is it going to say what you're saying it says?
Yes.
Well, they offered to let you, if you don't want to respond to all that stuff and do all the, figure it all out, which is not easy without an attorney, all you had to do is sign proper releases or authorizations, and they would have made it their headache. But you didn't. And the commissioner made that clear as well. You don't want to go through all that, you don't have an attorney,
He
you don't know how
told
to
me that I had-
respond, sign the play papers and let them get the records.
He didn't say that.
And
He
if the
said
records don't support what they're saying, then you're fine. So,
Okay.
So it's 4.5 to 2.5 days for now with some level of teen discretion. Now, if the boy decides he's not going to comply with this and he's going to be with the parties each half the time or with mom more than dad, then it may not be a heck of a lot I can do about it, I mean, he's 15, so I don't know, Dad says he's moving into the district, but if he does move into the district, and she's saying her son wants to be mainly with her, you're saying your son, I don't know what you're saying. Are you saying he wants to be mainly with you, or what?
I think that no matter what their mom is or what she's done, that's still their mom. They love her. So I think no matter what she is, all I want to do is see her get help. That's all. I just want to see her get clean and sober. That's it.
She won't, because she doesn't acknowledge that she's over-medicated, and she believes it's to address a legitimate medical condition.
I understand.
Maybe
it.
she's right,
But what I
maybe
don't
she's not,
understand,
but
Your
I don't
Honor,
know, because we don't have the records.
what I don't understand, Your Honor, is how can you go 13 years and not do anything but take Oxycontin? How can you go and hike and ride bicycles around
Well,
McNeese
that's part of the problem of why
and claim
the
that
court-
you're disabled?
In addition to not responding to the discovery, the facts of this case, independent of that, suggest that there's some serious unanswered problems. If you really were precluded for a decade or more from working due to severe injury, they would have approved you. Being approved has nothing to do with whether he's making too much money or not. That's not the way the law works. If he earns too much money and you're living with him or something, maybe that has an effect on the amount of the benefit you receive, or if you have money from other sources. But your marital status or how much someone earns who lives with you has nothing to do with whether you're going to be medically ascertained by that physician as having a disability. That's a completely different question.
I
So,
have the paper from Social Security saying that it was based on his income.
but not the denial of that may be
Your Honor.
the actual reduction or denial of a monetary
what-
benefit at this time, but it has nothing to do with an actual physical disability rating.
I think what it is she was denied, and it's probably too late under her plan. She's now trying to
Right.
apply under his benefits, which may be, but
Yeah.
there's a separate issue.
I know.
We'll prepare the order, Your Honor, submit to you, or the decree
Please.
submit to you. Thank you.
And again, make sure you provide her the notice of injury. If you don't have
We'll
any
give her the
income,
notice
why
of
didn't
injury.
you go to the public agencies, which I had suggested and the commissioner did too, the Nevada Legal Services, the pro bono agency. It doesn't cost you any money to talk to lawyers for free and see if they can represent you for free.
I
So-
did go to the legal aid class and they said that if I had a hearing date scheduled within 8 weeks, that they couldn't get me an attorney in that time.
Okay.
I have the papers showing
Okay.
that I went to it.
Just submit the decree directly to the Chambers, and if you produce the medical information they want and sign the releases, there may not be a problem. Now, that all said, as a practical matter, as I mentioned, Mr. Miley, despite the ruling of 4.5 days to your client and 2.5 days to her, if the boy elects to be with them half and half, there's probably not much that can be done at his age. If he elects mainly to be with mom, as a practical matter, it may not matter so much what the order is, so as a practical matter, and your client recognizes the reality of that. We're not dealing with an 8-year-old.
No, I understand. Would the court prefer if I added, say, the HIPAA release and or the discovery attached to the decree and reference it in the decree?
Well, sure, if you wish, but...
I mean, whatever the court...
It's much more likely that she's going to sign a HIPAA release than go wade through all that discovery.
Well, we're asking that at this point, she do discovery, because one of the things is we're asking where she went to see a treater, physician. So we're asking for the discovery, so I just want to make sure we're clear about it.
But unless someone repetitions the court, I'm not going to...
No, I'm just saying
go through all that yet.
No, I'm just saying if she repetitions, we're asking for the discovery. If she doesn't,
If she
it's done.
repetitions, you have to have the discovery because or the release because they're entitled to know about the medical circumstances. But if she's not going to repetition the court, I'm not going to.
No, and that's what we're asking. If she repetitions,
Burden her with all that, yeah.
No, and I want to make sure it's an and, not an or. I just want to make sure we don't get blindsided. We come in, we don't have the chance to look at her
No,
stuff.
if she has a medical letter and she believes that entitles her to restore custody or joint physical custody, and you still don't have either the releases and or the discovery in order to respond to that, her motion would either be denied or you'd be provided sufficient time
And that would
so
kind
that
of
she
void.
can provide all that. And if she still doesn't provide it, then at the return hearing, her motion would be denied.
I was just trying to avoid the
Right.
extra time, so
Right.
that's all. But
Sure.
thank you, Aaron. We'll prepare
Okay.
and we'll...
Thank you.
Thank